Good day. I am Azia Bibaliad. I am second year BS Criminology, study at Holy Cross College of Davao, and now I am reporting the evidence in crime. Before we go to our main topic for today, let's just know what is the outcomes of this topic. We were able to recognize and understood the legal kinds of evidence, and second is to identify the individual and rules value of presented evidence in the crime, and third is to acquire a theoretical or practical skills in collecting, marketing, tagging, and preserving evidence. And the fourth one is the we will able to apply the proper P&P procedures on processing pieces of evidence and the crime scene. So we will going to know their secret and how they preserve evidence, how they deter crime, and how they elevate or how they eliminate crimes in a society. Not killing someone, but knowing who is the responsible of the crime, something to put it into justice, because we have a justice system, so something like that. Lesson 1, evidence definition of evidence. So here it says that evidence is a legal definition. It is the means sanctioned by these rules of ascertaining in judicial proceeding the truth respecting matter of fact. So when we say judicial proceeding, it is the any action that is a judge or the judge will presides. It is concerned a judicial proceeding. So in the specific definition, proceeding is the or we say judicial proceeding. It is happen in a court, and the one who judge the evidence or the evidence that is found in the officers or the person who are in charge in the investigation. So when we say judicial proceeding, it also the quasi-judicial is also are part of this judicial proceeding, because it ascertains the facts. It hold hearings, weight evidence, make conclusion from the facts as the basis of their official action, exercise discretions of judicial nature. So that is why quasi-judicial proceeding is involved in judicial proceeding. So here is the picture. So it is the envelope of here is the evidence. So before, after all the evidence that gathered, it will present to the judge, and the judge or the judicial proceeding will decide if it is the fact, or the judge will say guilty or not guilty, something like that. Second is the evidence also refers to any material which tends to persuade the court of the truth. We have the oral testimony, the commentary, and real and circumstantial evidence. So oral testimony, it is the first form of evidence is oral. So oral testimony is the first form evidence of the done by the officer. So this testimony or oral testimony is from the witnesses or from the witness that is used to support or refute written evidence, or to be the part of the written evidence, something like that. So oral, it means witnesses are during the trial. So it is done by the witnesses. Documentary, it is the documentary in the crime that is happened in the place, something like that. So documentary is the pieces of fact, event, written, printed, or taking pictures. And third is real and circumstantial evidence. So it is also said that real is a direct evidence because the person is actually observes there, and the circumstantial evidence, it is the evidence that was not observed but from which a judge or jury could infer that an accident is occurred, something like that. The third one is the evidence refers to all means by which any alleged matter of fact whose truth is investigated at judicial trials is established or disproved. The term evidence, as it is relates to investigation, speaks to a wide range of information source that may eventually inform the court to prove or disprove points at issue before the trier of fact, before the fact is given, something like that. So evidence forms the building blocks of the investigative process. Any for the final product to be built properly, evidence must recognize, collected, documented, protected, validate, analyzed, disclosed, and presented in a manner which is acceptable to the court. So evidence must be fact, evidence must be appropriate, evidence must be in a good condition, that is not have been touched by someone or even the officers. That's why they are using gloves. That way the investigator using gloves, so that their fingerprint may not be damaging the evidence. Three forms of evidence, or the three forms of evidence in crime or criminal investigation. First is physical evidence, object or authentic or real evidence. It is refers to physical object used as evidence which is obtained through the researches at the scene of the crime. Legally object evidence refers to evidence made known or addressed to the sense of the court. It is not limited to that which is known through the sense of visions, but is extended to what the sense of hearing, taste, smell, and touch is preserved. That is the physical evidence. We have the firearms fired ammunitions, knife or kubo. So this is the type of physical evidence. The blood, semen, saliva, human or animal biological samples, any kind of biological samples, we considered as physical evidence. Finger and footprints, physical evidence. Tool mark and tire tracks, and the hairs, fibers, glass, paint, and other trace evidence. Anything that can be traced is physical evidence. So, category of physical evidence. So, first we have the associate evidence. These are the pieces of evidence which is link a person to a crime. The offender may leave clues at the scene such as weapon, tools, garments, clothes, something like that, fingerprints, and broken headlight or glass. We all know that an officers always touch the back of the car, so it is also included to the physical evidence because their fingerprint may leave there when something happened to that officer. He may be or that investigator may investigate it and will find his fingerprint. That's why fingerprint is very important, because an investigator may able to know what is the what happened in the situation or in that area. Number 2 is tracing evidence. These are evidence that may assist the investigator in locating the suspect. Aircraft, of ship, manifest, physician's clinic, record showing medical treatment of suspect for injuries sustained in the encounter, blood stains recovered from the area traversed by the wounded suspect, and fear direction of the movement are examples of tracing evidence. Biological and transient evidence. Biological evidence, it refers to evidence that is commonly recovered in a crime scenes. It is an evidence that can be tested through DNA mapping and other profiling methods. Biological evidence that has DNA include blood, saliva, semen, sloths, skin cells, hair, urine, and fecal material. So it means sty, something like that. Transient evidence, it refers to evidence that by its very nature can be easily changed or lost. For instance, transient evidence includes temperature, odor, blood in the rain, and some biological and physical phenomena. What is corpus delicti? It is in Latin, it means body of crime. It is the legal term used to describe physical or material evidence that the crime or a crime has been committed, just as a corpse of a murder victim or the cleans of a torch building. Other specific kinds of physical evidence. Number 1 is soil. This consists of organic natural materials such as rocks, minerals, and decomposing plant, and may also contain man-made materials such as bricks, concrete, glass, or paint. It is indicate match this common scientific technique of analyzing soil is called the density gradient tube. This is the density. This is what we call soil. Is paint. Paint is pigment polymer that is applied and adhere to various surface as well as to determine through the use of gas chromatography. This is the gas chromatography. Third is the tool mark. Tool mark is any mark that is created when an instrument is contact with another surface. Shoe paints and impressions. Shoe prints are created when material from the bottom of shoes is transferred to another surface, leaving the outline of bottom of the shoe. This is bad. Videotape evidence. Videotape evidence is potentially extreme powerful for evidence. It is a crime is captured on video, or it also part of the documentary. 6 is dental evidence. The two primary kinds of dental evidence, we have the dental identification and the bite marks. This one. Computer and other electronic evidence. Computers, cellular phones, and personal digital assistants may provide a wealth of information regarding the communications, schedules, and criminal behaviors, and therefore are potentially valued source of evidence in criminal investigation. This one. That. Testimonial evidence, it is also known as eyewitness testimony. Communicative evidence, it is the product of interview and interrogations from which witness smell, hear, taste, and touch are being described through the oral and written testimony. Kinds of testimonial evidence. First is the ordinary witnesses. Any person who perceives and commissions or a crime are testified before the court is just considered as an ordinary witnesses. Expert witnesses or expert witness, a person whose testimony concerning the investigation of crime is based on his training and experience. Who is witness? A witness is a person who testifies under oath in trial or deposition in the lawsuit. The plaintiff or defendant may be a witness. What is deposition? It is the testimony taken orally with an attorney asking questions and the deponent, the individual being questions, answering while the court reporter or tape recorder or sometimes both records the testimony. So it is the deposition. 3 is documentary evidence. It is writings including the official records or the contents that could speak for themselves, and when read by the investigators and the court, documentary evidence are but not limited to the following: birth and death certificates, necropsy report, and medical examination.